Good evening, everyone. Welcome to the 9th annual Buck Colbert Franklin Memorial Civil Rights Lecture. I am Janet Levitt, the Dean of the TU College of Law, and it is truly a pleasure and an honor to welcome you to this event, this annual lecture on civil rights that is just so significant to our college, to our university, and to our community. This past weekend, there was a movie that was premiered in Tulsa that was called Before They Die. This was a movie that captured the story of the Tulsa race riots, which many in this room have been involved in sort of recapturing that story and bringing that to light in Tulsa. And this lecture celebrates the legacy of Buck Colbert Franklin, who endured the race riots. According to his son, John Hope Franklin's autobiography, his father, Buck Colbert Franklin, was caught in Tulsa during the race riots. He actually had left his family in one of the black towns in Oklahoma to go set up a law practice, found himself here during the riots, and instead of going back and being with his family, he stayed in Tulsa to represent many of the victims of the Tulsa race riots. And so the family was actually separated for a couple of years. And we inaugurated this series in October 2000 to celebrate the life of Buck Franklin, who was dedicated to civil rights, to decency, and to the basic principles of humanity. This series started with a lecture by his son, the famous historian John Hope Franklin, and since that inaugural lecture, we have been informed, inspired, and challenged by many scholars and activists, including Morris Dees, the founder of the Southern Poverty Law Center, Charles Ogletree, a Harvard Law professor and a distinguished reparations scholar, Julian Bond, civil rights activist and NAACP chairman, and last year Brian Stevenson, an NYU law professor who also fights for death row inmates and for racial injustice in the South. And I think that it is so appropriate that we have tonight's speaker, Brandon Garrett, to continue this legacy of thoughtful insight, thoughtful discourse in the area of civil rights, equality, decency, and humanity. Brandon Garrett is an associate professor of law at the University of Virginia. He has published extensively in the most prestigious law journals in the country. He clerked on the Second Circuit. He practiced in a boutique civil rights practice firm in New York. And he has made his contributions to civil rights law in a way that I think we as scholars really strive to reach, which is that taking our scholarship, our research, our writing, and our practice, and coming across ideas and conclusions and empirical insights that are so profound and so insightful that they are helping hundreds, if not thousands, of people on the ground. Professor Garrett's impact has been real impact has been in using his scholarship and his practice to shine a light on a very severe problem in our criminal justice system. In a recent article called Judging Innocence that appeared in the Columbia Law Review, he revealed startling numbers of innocent people who are in prison and on death row, and found a far greater rate of wrongful convictions among minorities, primarily blacks and Hispanics. His work has directly and indirectly exonerated dozens of innocent people, and furthermore, it has clearly shown the need for significant reform to our legal and criminal justice system. Ladies and gentlemen, please join me in welcoming from the University of Virginia School of Law, Professor Brandon Garrett.
Excuse me while I pour myself a glass of water. Thank you so much for having me here. It's a real honor. It's intimidating to be in the company of those who've given this lecture before, and it's an honor to be here at this lecture named after a great Oklahoma attorney. Thank you to everyone here who helped organize this event and made it possible. Again, it's a pleasure, and I look forward to talking. I take it I'm supposed to talk for a little less than an hour, and there'll be plenty of time for questions. I have a phone here to help me keep track of time. I'm used to using one in class. So my talk is going to focus on just a few exonerations here in Oklahoma to sort of give you a sense of the kind of work that I'm doing, because there have been 223 DNA exonerations, but to go through all of them I'd have to talk awfully fast, and I would need more coffee, I think, to cover all 223. I will, though, begin sort of in the first preliminary part of my talk, give you an overview of my more general research looking at these unique DNA exonerations, and talk to you about how I got involved in this work and what that general research has shown. And then I'll turn to talking about a new project that no one can read until the spring, which looks at a slice of these cases, a particular set of issues in these trials, the use of forensic science testimony in these unusual trials of people who were later exonerated by DNA testing. While my talk will dwell on exonerations from here in Oklahoma, that's not because Oklahoma is unusual in any particular respect. Plenty of exonerations in Virginia, where I hail from, and even more exonerations where I used to live in New York. Not because New York is unusual either. Actually, it may be because New York had a very good innocence project, and there was a very good statute early on providing access to DNA, so there are more exonerations there. Or it's also a populous place. But that sort of brings to light an issue, which is, we'd all like to know how many innocent people there are in our prisons, whether these 223 are a drop in the bucket or most of them. And, if I could answer those questions, I would run out the door and, be telling people right away, studying the 223 cases that have come to light can't tell us how many others have been wrongfully convicted. It may be many, it may be few. We can talk about icebergs and tips of icebergs. We don't know how big the tip is. We don't know how big the iceberg is. It might be small. It might be large. It takes hard work to uncover exonerations. And we don't know how many there are. And, DNA testing can't be used in many criminal cases. Maybe, perhaps in most criminal cases it can't be used. You have to have biological evidence that was relevant to the question of who did the crime. That evidence has to be preserved, so it could be tested, years later. And so, these 223 cases are all cases like that. And so it's a limited and in some ways highly selected sample, and I'll talk a little bit more about that. These people did spend quite a bit of time in prison, although for the reason that if their trial was recent, they wouldn't have had to spend so long before they needed to get DNA testing. People are not exonerated, but they're excluded by DNA testing before trials now, since it's regular practice for DNA testing to be done before trial. And there are, according to FBI statistics, many thousands of people who are excluded as suspects in criminal investigations, and they never see a trial, which is a wonderful thing. So a lot of these people, there's a time lag. A lot of these trials that I'm going to talk about are in the 1980s, before DNA was widely used. Some of them are more recent. And, because of that time lag, these are all people who spent a fair amount of time in prison for crimes they didn't commit, which makes these cases particularly tragic. 17 of them faced the death penalty, were nearly executed. Some were convicted at multiple trials. They had their convictions reversed multiple times until they finally had DNA testing available. So, I'm going to talk a little bit about 9 exonerations in Oklahoma, really focusing on 7 of them. And it's customary, I think, to try to tie the subject matter of the talk to the title of the lecture. I'm not sure I can do that very well. I could talk about, frankly, the criminal courts pass the buck on this or something like that. But I won't try to do that. And it's also a little strange, I guess, for me to be talking about a criminal justice issue. But I do think that there is a new civil rights movement that has grown up around these cases, with a lot of law students, including at law schools like UVA, where there are innocence clinics, a lot of civil rights organizations dedicating resources to trying to find these people, because it really is a new thing in criminal law that there are these special cases where we can have convincing evidence that someone is really innocent. That's not something that was easy to show before. You read about cases from colonial times where someone was about to hang for a murder, and then the supposed murder victim shows up in town, and where'd you go, Larry? We lost touch with you. We thought you'd been killed. Aside from cases like that, it was hard to have a clear-cut exoneration in the same way that DNA can. I came to this work working with the founders of the Innocence Project, the first one, the one at Cardozo Law School, Barry Scheck and Peter Neufeld. When I was my first job as a lawyer, was working at a small civil rights practice that they had, trying to seek compensation on behalf of people who'd been wrongfully convicted. But I'm an academic now, and my first study of these wrongful convictions, which came out earlier this year, called Judging Innocence, I'm partial to short titles, looked at the first 200 of these DNA exonerations. There have now been 223, and I had to cross out the 2 and put a 3, because every week, the numbers go up, every couple of weeks. There's been a steady stream of these DNA exonerations, although 223 cases is many more than we ever knew existed, but we don't know what that represents again. First, what's a DNA exoneration? You hear the word exoneration used a lot. It has a somewhat technical meaning, really, because there are people for whom DNA testing was done post-conviction. The DNA evidence didn't match them, and they're still in prison today. It may have been evidence of their innocence, but the courts thought that it wasn't compelling enough. For all of these people, the DNA testing excluded them, and was considered such powerful evidence of their innocence that their conviction was vacated. So their conviction was reversed, usually by a court, but sometimes by a governor in the form of a pardon. And getting a vacatur isn't the end of a story for a convict. There was no retrial, at least once the new evidence of innocence turned up. Some of these people had endured several trials before they got DNA testing. For all these 223 people, the DNA testing was sort of the end of their ordeal. And obtaining a vacatur like that often takes a long time. These exonerees brought extensive post-conviction proceedings, and the subject of my study was looking at what kind of claims did they raise during this time before they got the DNA testing. Once they get the DNA testing, things can move a little bit more quickly. You have this powerful new technology. Before they had that powerful technology, I was wondering, did they allege their innocence even? What did they do during their appeals? If we know now that they falsely confessed, did they raise that issue during their appeals? If we know now that the eyewitness got it wrong, did they try to challenge the eyewitness during their appeals or habeas proceedings? And what happened? What I found that was somewhat surprising, but maybe not if you're sort of a cynical observer of post-conviction law, or if God forbid you was that, most of these people did not bring innocence claims. Not because they didn't think they were innocent. Presumably, most of them, except maybe some of them who were mentally retarded, and that was an issue in their wrongful conviction, most of them were aware that they were innocent, and nevertheless chose not to assert it. And that's because legal claims of innocence are not easy to win on. You could have a smart post-conviction lawyer who would tell your client, that's a frivolous claim. You may say you're innocent, and you can wave your hands all you want, but you'll discredit your case because you have no evidence to back it up. And many of these people do not have evidence to back it up. But there's no federal innocence claim. There's sort of a hypothetical claim, which some of these people tried to assert, and they didn't succeed. And the standards for some of the state law claims related to newly discovered evidence of innocence can be quite onerous. So some of these people tried to raise their innocence, they all failed. Far from recognizing innocence, a lot of courts along the way, and no surprise to observers of post-conviction law, said that the errors were harmless. That these people were so obviously guilty. There was even a fair number of courts that said there was overwhelming evidence of guilt. That these were the kind of cases where it was overwhelming that the person committed the crime, and therefore their constitutional rights were violated, but the error was harmless because the prosecution case was so strong. In retrospect, the prosecution case in some of these cases looks weak. Some of these cases, you read the trial transcript and you could see why the person was convicted, often because of other problems with the evidence that were not apparent on the face of the transcript. And I'll talk a little bit more about that today. Many of these people, therefore, did not challenge the confession, the eyewitness, the forensic evidence, which in retrospect we may have questions about. But they had no foundation to challenge it, or those kind of substantive claims are not easy to win on. So the few that did typically lost, although there was a subset of these exonerees that did get reversals along the way. And many of those were ones that really did have evidence of their innocence, and courts remarked on their innocence when they reversed their convictions. So there's 14% of those 200 exonerees did get reversals. They got their convictions vacated. All of them either got reconvicted again, or they got DNA testing after the conviction was vacated. But some of them endured 2-3 trials before finally they got the DNA testing that exonerated them, which is also what an ordeal, right? To be tried and convicted several times for a crime you didn't commit. One final little piece of that study, I did a matched comparison group that I assembled to look at, were these exonerees atypical or not? Let's look at people convicted of the same crime, similar rape and murders, mostly rape, because these are cases where DNA evidence could say something about the identity of the attacker. So similar cases and similar in the same states, same years, reported cases matching to the exonerees that had reported cases. Presumably these random cases on Westlaw are all people who are basically guilty. We don't know. They're cases without DNA testing. Did that random group of matched cases look different or similar? And it actually looked exactly the same. Same percent got reversals. And what that may reflect is that there's a fairly high reversal rate in these more serious rape and murder cases. Also in those cases, most of the reversals had to do with substantive errors at trial. So just as there's a high reversal rate in death penalty cases, often having to do with sort of innocence issues, same thing true in this more intermediate category of mostly not death penalty, but serious rape and murder convictions, which should trouble us that their courts find so many substantive errors in those cases. But the experience of these innocent people was similar to those tried for and convicted for similar crimes. Also troubling, there are a lot of exonerees who were convicted even though DNA was available at the time of their trial. With that, a quarter of exonerees. And what that suggests is that even though DNA technology is in wide use, we may still see these DNA exonerations for quite some time. Even though DNA is in wide use before trial, a lot of these people had lawyers that didn't tell them about the opportunity to seek testing. Plenty of these people benefited from new DNA technology, and we've seen constant improvement and evolution and development of new DNA technologies. And there were, for some people, evidence, the existence of biological evidence was concealed from them, so they didn't know they could get DNA testing. And there are still other people for whom the DNA testing excluded them at the time of trial, and they were convicted anyway. I've now turned in my research from the subject of what kind of claims these people raised during their appeals to look instead at their trials. And these are fun trial transcripts to read. Reading trial materials is always enjoyable. My students enjoy reading these trials along with me. You do have to have a certain dark sense of humor to be reading this unique group of trials where we know the person is innocent, and it makes things look different in retrospect. One project looks at the 34 who falsely confessed to see what happened during their trials. How was the confession litigated at their trials? The project that I'd like to talk about today involves many more than 34. More than 150 of these 223 exonerees had some kind of forensic testimony at their trials. Some of that testimony helped them. It was exculpatory. Most of that testimony did not help them and was inculpatory. And most of that testimony involved forensic analysts that worked for the state in one form or another, either at a police crime laboratory or at a state crime laboratory, a few private analysts. Issues related to forensic science and wrongful conviction cases aren't news to you in Oklahoma. There have been scandals at several laboratories around the country that have emerged from some of these wrongful conviction cases, or just from other unrelated cases. Joyce Gilchrist's work in Oklahoma came under scrutiny after 3 exonerations in some of the cases that I'll talk about. But many of the people who come up in these exonerees trials are not Joyce Gilchrist or analysts that anyone has read about in the newspapers. Many of these analysts testified in an appropriate manner, and many of them did not, as I'll talk about. But not necessarily because of any bad intent or state of mind. We can't tell that from a trial transcript. All we can do is look at the transcript and see whether or not the testimony comported with sound science, and that's what I'll develop today. Where this project came from, it's a paper that'll be out in Virginia Law Review in the spring. It's co-authored with Peter Neufeld of the Innocence Project. We've been working together on this. He's been working on forensic science issues for some time, since the Castro case where DNA was first litigated in New York. Where this came from was that Congress, as some of you forensic scientists in the audience may know, has tasked the national academies with forming a committee on identifying the needs of the forensic science community, which will soon release a long-awaited report, maybe later this year. That committee contacted me about my work on wrongful convictions and asked if I would present to them some data on the use of forensic science in these particular interesting and unusual and compelling cases. I said that that would require a fair amount of work because I would have to read the trial transcripts, and they sort of said, well, the committee would appreciate it if you would do that work. And so with Peter Neufeld's help, I've been trying to do that, and that's what I'll talk about today. I do think this is a really exciting time for the future of forensic sciences. We don't know what this committee's report is going to say, but presumably it'll talk about a new investment that we can make in the quality of forensic science in the U.S., which will hopefully benefit everyone in our criminal justice system. Among the committee's tasks was to address needs for further research and funding for basic research in some forensic disciplines. For many of these forensic disciplines, it wasn't like DNA where there was an interest of the private sector in investing finances in doing basic research because of a biotech interest in the underlying science. Many of these forensic sciences originated to help solve important questions in police work, but not with private sector resources. And so there is no agency comparable to the Food and Drug Administration or something like that to look at forensic devices and assays. There's NIST. But again, the Academy's efforts may lead to more of a national investment in improving the quality of forensic sciences and to help ensure a better product. But that's not the issue that I'm going to talk about today. The subject of my talk is not whether particular forensic science techniques have been validated or whether there's been sufficient basic research or whether they've deemed reliable for casework, sort of Daubert issues that other people have talked about. Instead, what we're simply looking at is assuming that a particular forensic discipline has a rock-solid foundation, how do we ensure that the data will be presented within appropriate scientific parameters in reports and at trial? And I think that's what makes these cases interesting, because so many of these exonerees, they're not like normal criminal defendants. Most criminal defendants plead guilty, right? But most of these exonerees had trials. And most of them, because they were convicted of rape, had trials where there was some kind of forensic science testimony. To look at forensic science testimony in the courtroom. Traditionally, there has not been much oversight of what scientists say in the courtroom. Once the court does its sort of Frye or Daubert gatekeeping inquiry and deems that the method used was valid and reliable. And, it was assumed that forensic scientists adhered to scientific standards, and in the event that one, crossed the line, cross-examination, the crucible of the court, a young Clarence Dow like one of you, would illuminate any inaccuracy and help the jury to understand a different view of the facts. And the idea is, that the jury will ultimately weigh the credibility of the expert testimony and weigh how it interacts with the other evidence in the case. So, to look at the problem of testimony in the courtroom, which we think is under-examined, Peter and I examined for the first time a set of criminal trial transcripts in these cases of DNA exonerees. We talk about whether that forensic science testimony was valid or not. What we mean by invalid is not, anything related to whether the testimony was proper or ethical or the state of mind of the person testifying, but just whether it comports with scientific criteria, which we simply mean just was it supported by empirical data or not. So again, we're not looking at the methodology or whether it's reliable and produces consistent results. We're just looking at whether the conclusions expressed by analysts were supported by empirical data or not. In some respects, in that way, this talk isn't really about wrongful convictions. We're not making any causal claims about what causes wrongful convictions. We don't know how jurors reach their verdicts. Forensic science was only a part of the evidence in any of these cases. Typically, there was other evidence in the case, too. We don't know if a mistake or error related to the forensic science caused any particular conviction. We don't, in our system, know how juries reach their results. All we can say is that forensic evidence played a role in some of these trials, and that some of that evidence was presented in a way that didn't correctly characterize the scientific import of the evidence. Now, I mentioned this. Examining one other caveat is that examining forensic science testimony in the cases of DNA exonerees has important limitations because these are not regular criminal cases. About 155 of them had testimony concerning forensic science at their trials of the 223 exonerees. That's a lot of them. And again, one advantage of looking at those cases is that we were able to obtain a lot of those transcripts. And a lot of those transcripts happen to have forensic science testimony. So, looking at random cases, sometimes you come across cases that have forensic science testimony, sometimes you don't. Many also had post-conviction lawyers seeking DNA testing who retained copies of these trial transcripts. Trial transcripts aren't easy to come by necessarily in our system. You have to sort of go hunting courthouse to courthouse, and it was still, even with these cases that have received a lot of scrutiny since, it was an undertaking to even sort of locate these materials. There's no body that systematically looks at forensic science testimony any more than there's any body that systematically looks at criminal trial testimony in general. However, the same features that made this set an attractive subject to study also makes this set unrepresentative. So these are all erroneous outcomes, innocent people, presumably not typical criminal cases, right, for that reason alone. We expect and hope that, most criminal cases don't involve criminal convictions. In addition, most exonerees were convicted of rape, since in such cases DNA evidence could later shed light and be highly probative as to the issue of identity. So, most of these people were convicted at trial. Very few criminal defendants are convicted at a trial like these exonerees. Very few criminal defendants are convicted of serious felony rapes, like almost all of these exonerees. The data set has other limitations. Most of these trials involve 1980s convictions before DNA testing was common. That's how they became exonerated later. So just as we don't know how many more wrongful convictions there are out there, we don't know how large a problem we have with the kind of invalid forensic science testimony we happen to observe in these particular cases. These cases are just observations, examples. Data from these trials don't even tell us whether the kind of testimony we saw was common in these kinds of cases in the 80s, because we only have these cases involving these wrongful convictions. And they certainly don't tell us what kind of testimony, invalid or not, is common today. To answer those kind of questions, you'd have to do a broader inquiry into testimony, other types of cases, current cases, and such an inquiry, though desirable, would face practical difficulties because trial transcripts are expensive and difficult to come by. The purpose here, having obtained some data from this unrepresentative but very interesting group of innocent convicts, is simply to describe the testimony in these trials, and it provides a body of examples, for what it's worth, that do suggest a worrisome problem. Not a problem of wrongful convictions, really, but a problem related to standards for scientific testimony. And so again, without making conclusions about the size of the problem, this data simply points to a need to further investigate testimony in the courtroom, particularly where the kinds of things that experts say on the stand in criminal courts are largely unregulated by those criminal courts. And for that reason, really, the purpose of this talk and the purpose of our article is not to address lawyers, but it's to address scientists, and to say that lawyers need help. Scientists could really provide some guidance by setting out the kind of standards that could make clear what's permissible and what's not in the courtroom, and what comports with science and what does not. So let's talk about what we found. We've obtained trial transcripts for most of these cases, and in about 60% of the 134 cases that we looked at, there was a forensic analyst called by the prosecution who provided invalid inculpatory testimony. There was also, other cases, 40% where there was valid and appropriate testimony. Quite a bit of that testimony involved evidence that was, by the analyst's admission, exculpatory, help the defense, or inconclusive. This invalid testimony chiefly involved the kind of forensic disciplines that you would expect in 1980s era rape cases. It mostly involved serology analysis, ABO blood typing chiefly, but some other kinds of blood grouping and blood enzyme typing, and a microscopic hair comparison. But also a few other forensic disciplines. There's some more recent cases involving DNA analysis, some cases involving bite mark analysis, a few shoe print, fingerprint comparison cases. And this wasn't a problem of a Joyce Gilchrist who had audits and investigations about several cases. Most of these analysts testified in one case in our limited group of cases from around the country. The invalid testimony that we found involved 72 forensic analysts employed by 52 laboratories in 25 states, sort of spread all around. There are two types of testimony that we deemed invalid, and I'll explain what we meant by it. And it was fairly straightforward, I think. There was testimony that was invalid in the sense that empirical population data was used inaccurately. So the wrong statistic was given, basically. There were other cases where conclusions regarding the probative value of evidence were delivered even though they were unsupported by any data. So there was unsupported by data, or just there was data, but it was the wrong statistic was given, something to that effect. Just to sort of give two quick examples from Oklahoma, in the Curtis McCarty case, that's an example, maybe a case, some of these Oklahoma cases you may know much more about or just be more familiar than I do. I've read trial transcripts. Curtis McCarty case is an example of the first type. So there, the analyst testified that McCarty was included in 13% of the population that could have been the semen donor using conventional serology. And I'll talk about this case a little bit more, but the proper statistic was that 100% of the population could have been the donor. So that evidence actually shouldn't have told the jury very much. So it was the wrong number. So type of invalid testimony number two, it was in Timothy Durham's case, which I believe is a Tulsa case. The analyst there opined that the particular reddish yellow hue of his hair was unusual and shared by about 5% of the population. Now, there is no empirical data on the frequency of hair characteristics, and thus that statement was unsupported. So it wasn't the wrong statistic, it was a statistic that was unsupported by data. Of the 9 Oklahoma exonerations, I was able to obtain trial transcripts in 8 of them. Still looking for the last one, but I think it may be sealed. And there are some good examples just in that group of Oklahoma cases which illustrate the kinds of things that we found in all of the cases. Although there were no Oklahoma cases involving bite testimony, fingerprints, or a couple of the things that appeared less often, given the composition of this unusual group of cases. So first, I wanted to talk for a few minutes about Curtis McCarty's case. It's a case that many of you have probably heard about. In his case alone, illustrates several of the different types of forensic science issues that we write about in our draft. He was exonerated in 2007 after serving 21 years, including 18 years on death row for a 1982 Oklahoma City murder that we now know he didn't commit. He's one of these exonerees who had several trials. He was convicted twice and was sentenced to death 3 times. He had a resentencing after his second trial, and eventually he was exonerated. The crime, like many of these crimes, was a high-profile, gruesome crime, kind of crime that any department would be a high priority to solve. It was a 18-year-old victim who was found murdered in her Oklahoma City home where she was staying for work. She'd been stabbed. She'd been strangled. The police suspected him because he was an acquaintance of the victim. It's a sensible reason to suspect him if you don't have too many leads. And I'm not using names of victims today, of course. Soon after the murder, Joyce Gilchrist, whose name I do mention because she's a familiar name, whose her flawed forensic work has been widely reported. The governor, as you know, ordered an audit into several of her cases. She was assigned to the case. She worked for the Oklahoma City Police Department. There are more than 350 forensic labs in the United States. Most state law labs run by law enforcement, or some larger cities like Oklahoma City, the police department has its own laboratory. In Virginia, there's a state crime laboratory, but a city like Charlottesville doesn't have its own forensic unit, really. So back to Gilchrist, there are 2 types of analysis that were done in Curtis McCarty's case. There are some crime scene hairs that were compared, and there was some serology evidence. Gilchrist compared hairs from the crime scene with the McCartys and found that they are not similar initially, as we later found out. But police interviewed McCarty several times over the next few years. He wasn't arrested until 1985. It was an investigation that went on for some time. After his arrest, Gilchrist, we later found out, changed her notes and reversed her findings, saying that now the hairs could have been McCarty's. But no one discovered this until, the McCarty's attorneys at least didn't discover those notes until 2000, when she was under investigation in other cases. In most of these exonerees cases, there's no issue like that. If evidence had been concealed like that, often it stays concealed. So we don't know if this occurred in other cases. There've been a few cases like McCarty's where something unusual like that comes to light, where the analyst actually concealed exculpatory evidence. What I'd like to talk about is not that, but the evidence that wasn't hidden, the evidence that the testimony at trial concerning the forensic science. So first I want to back off and talk a little bit about hair comparison for those of you who aren't used to comparing hair, except in the sense of looking at people's haircuts and hairstyles and things like that. Forensic hair microscopy involves not looking at hairs with the naked eye, but looking at them side by side using a microscope, and not, hopefully not just there may be one hair found at the crime scene, or there may be many hairs. Often there's several hairs. People shed a lot of hair during the day, but the idea is to compare whatever is found at the crime scene with questioned hairs, or exemplar hairs they call them, from both the victim and from the suspect. And because hairs vary over someone's head or other parts of their body, questioned hairs, not just one hair. You're not going to just pluck a random hair from someone's head. They pluck a set of hairs from the suspect, so that they have a group of hairs to compare. And those are called reference hairs. Those reference set of hairs are then looked at side by side with whatever hairs are found from the crime scene, the questioned hairs. Now, as the National Resource Council has explained, although hair examiners can associate, I'm quoting, a hair with racial characteristics and the body source, like if they say it comes from the trunk, a head, or pubic area, the variations among hairs on a given person make definitive association of a single hair with an individual problematic. The microscopic comparison of hairs is also subjective and can lead to differences of opinion among equally qualified experts. What they mean is that it's a subjective methodology. There are lots of microscopic characteristics in hairs. There are different bodies and materials, and there are words for terminology for the different slices of a hair that you can look at. There's no consensus though on what are there 20 characteristics that you're looking for, or 15, or 20, or 30. The idea is to look at these hairs in detail and see if they're similar or not. There's no data on how many people have particular kinds of microscopic characteristics in their hair. Consequently, the field has adopted a standard in the mid-'80s that the strongest statement you can make is that these questioned hairs, the ones from the crime scene, are similar or are consistent with the suspect or defendant's hair, or that they could have come from the defendant. On the other hand, they could exclude, and they can say, no, these hairs have manifest differences. The FBI held a symposium in the mid-'80s to talk about these issues, whether there was any, to sort of talk about the state of the empirical evidence, and that's right during the time period when most of these trials occurred. Although, there was that sensible standard that the field adopted, the lawyers in these cases seem to not be aware that there was a limitation to hair comparison, and that all you can really say is that these hairs are similar or could have come from or excluded. So that's sort of one of the important messages, is that if there is a standard within the forensic discipline that's based on the empirical data or lack thereof, it's important for lawyers and judges to know it. These lawyers clearly didn't, because the defense lawyers, you didn't see them asking questions about that at these trials typically. Again, what we don't have are systematic empirical data or research on the frequency within which particular microscopic features occur in any population. So there is not, and never has been, any statistical basis for hair comparison. You can't say, only 5% of Caucasians have that particular reddish-yellow hue, or coffee color hair, or whatever it is, or ovoid bodies, or whatever the examiner is talking about. So what Joyce Gilchrist said in McCarty's first trial was that there was 100% certainty that this hair found that the crime scene came from Curtis McCarty. So a particularly strong individualizing statement, exactly the kind of statement that wouldn't have been proper. The NRC specifically talks about how even experienced hair examiners can disagree, and to express 100% certainty, this hair came from them, he was there, she said. A really unusually strong statement, which just wasn't supported by any kind of data. If she had said the hair is similar, may have turned out in retrospect that she was wrong because he was innocent, but there wouldn't have been any transgression in terms of the boundaries of the science in the field. So there was no scientific support that could be provided for such a statement that this hair came from him, he was there. Another case, the Calvin Lee Scott case, involved a different analyst. There, the analyst didn't say it was his hair that was there. And by the way, there are other exonerees where analysts made statements like that. It's not something particular to Joyce Gilchrist or Oklahoma. There are cases like that in other states that we came across. Other analysts that, like in Timothy Durham's case, even though there's no empirical support for that 5% people with the reddish yellow hair, also gave statistics where no empirical research supports such statistics. There were also analysts that talked about a probability or frequency without assigning a number, but also saying something about a probability non-numerically where there is no support for it. So in the Calvin Lee Scott case, the analyst says, his hair, I would say this. In this case, having two hairs identified, two hairs of different kind, I mean head hair from one person would be quite large, I would say. I would not give a figure, it would be quite large. And so what the analyst is saying is that these are independent events. And there are a bunch of other trials where the analyst says the same sort of thing, that the odds are amplified when you have more than one hair that looks similar. And I think we all know that there can be correlation between hairs looking similar on different parts of the same person's body, right? One person's hair is not independent, although there is variation within hairs on someone's body, but it might be quite likely that someone with dark head hair would have dark arm hair. Anyway, at a greater extreme, there's one analyst in a couple of the cases we looked at that assigned figures and multiplied them times the number of hairs that were observed to generate even larger figures to talk about how unlikely it would be that anyone's hair could match these crime scene hairs found at the scene. So those are all, again, examples of providing statistics where there's no empirical support. Back to McCarty's case. So there's hair evidence in his case. There's also serology evidence in his case. And it was, ABO typing, something I think we're all familiar with, although actually I don't know what my ABO type is. I guess I should. But DNA has largely displaced that kind of analysis. As DNA has displaced some analysis of hairs, if there's sufficient biological material, you can do mitochondrial DNA testing, which can provide significant information. You don't have to rely on the more subjective, microscopic side-by-side comparison. And serology was commonly used in rape cases at the time. Most of the DNA exonerations that we have involved rape convictions, and typically, in these cases at least, a rape kit was prepared with different swabs taken from the victim at a hospital, taken by doctors from the victim's body, and later on that rape kit became very important. That material was tested, and the DNA was what showed that someone else likely committed the crime. At the time, though, that wasn't available, and conventional serology was used. It involves analysis of fluids for certain markers that are lifelong individual characteristics. Our blood types don't change. Chiefly, again, based on the ABO system of blood group substances. Sometimes different enzyme markers that came up in a couple cases. Anyway, these are substances that are found on the surface of red blood cells. For about 80% of us, we are secretors, and these markers can be detected not just in our blood, but other body fluids, including saliva, semen, vaginal fluid, kind of fluids that appear in a rape kit, where there may be evidence, not only vaginal secretions, but maybe semen from the perpetrator. That's the hope in collecting that sort of evidence in a criminal case, is to uncover semen evidence that would tell you something about who the perpetrator of this crime is. Obviously, that's important in stranger rape cases, which are a minority of rape cases, right? They aren't even representative of most rape cases, which don't involve strangers but involve acquaintances. Almost all of these exonerees were convicted of stranger rapes, where one of the central issues was, who did this? Who was the stranger who did this? So a conventional serology can't identify particular individuals, but it can exclude individuals or place individuals within a percentage of the population that possess a given type. So, the ABO frequencies were based on sound empirical data, based on analysis of thousands and thousands of samples. It was observed that, 40% of Caucasians are type A, 11% are type B, things like that. So these were, sound empirical population databases. It's not like hair. There really was sound data providing the underpinnings for ABO testing. But the most crucial element of any conclusion expressed in a criminal trial regarding serology is what can you say about the population that was included by finding blood markers, blood group substances in a crime scene sample. The crucial statistic is, what can you say about the possible perpetrator of this crime? What percent of the population could have been the semen donor? That's sort of that's the question. In the Curtis McCarty case, the victim was an A secretor, which meant she was in the 80% of the population that secretes, and she has these A substances in her fluids. Curtis McCarty, also an A secretor. So, vaginal swabs from the rape kit were tested, and they exhibited A substances, A blood group substances. So those are consistent with Curtis McCarty, also consistent with the victim. When asked about this on the stand, what Gilchrist says is, and what did you determine the ABO blood classification and secretor status of the donor semen found in the victim's material? She says, semen donor is an A secretor. Is that consistent with the defendant, Mr. McCarty? Yes, it is. And on cross-examination, she says that 26% of the population is type A, and that was problematic. Now, the reason why is that, remember, the victim and McCarty were the same type. And while modern DNA techniques allow analysts to isolate and amplify, minuscule amounts of semen in a sample, so you can, focus in on the semen and amplify it, even if it's, a few dozen cells or something like that. That was an important advance because the proportion of semen in a sample might be quite small. And this was the problem of masking and non-quantification. So the victim's own genetic markers and the victim's own fluids could overwhelm any markers from the semen, making it impossible to detect the blood antigen type of the assailant, absent some ability to quantify the semen content of the sample. And later techniques were developed to do that, but not during the time when these people were convicted. So this was a big problem with conventional serology. It was one of its main limitations when you're dealing with these kind of mixed samples. So in a case involving a mixed stain in which nothing foreign to the victim is detected, serologists knew that absent additional information based on quantification, which these analysts didn't have, no semen donor could be excluded because those A substances that were observed could have come entirely from the victim. So that 26% statistic was not the valid statistic. The valid statistic was that 100% of the population could have been the donor. Could have been a type B, could have been a non-secretor, could have been an AB, because all that was observed was material consistent with the victim. And so the appropriate answer to that question would have been that this evidence is indeterminate. We observe nothing foreign to the victim. Any male could have been the donor. Now, Gilchrist then did a different type of error, and not only gave the 26% statistic, but divided it in half, saying, well, half the population is female. And said, well, you'd be looking at 13%, and then you take some off of that because of the 20% who are non-secretors. Now, 26% of men have that type, and 26% of women have that type. It's logically incorrect to divide a frequency in half when it's understood at the beginning that the relevant population is males. But regardless, the relevant statistics are identical for both males and females. So that was yet another twist in the case. Anyway, and that wasn't the only trial where that came up. There were quite a few exonerees where analysts did this false division, dividing the relevant statistic in half. But there were many, many more where there was this issue relating to masking and non-quantification, where nothing was observed foreign to the victim, and nevertheless the analyst gave some kind of subset of the population purporting to include the defendant. Now, fortunately, we now live in an era where DNA techniques can be used to isolate semen donor evidence, and so that issue may not come up as often. Although we do have one early DNA case here in Oklahoma where a similar problem arose. Again, there are quite a few exonerees trials where this came up. Unlike most exonerees, there are only 19 of these exonerees who had any kind of a defense expert. Curtis McCarty did have an expert, and the expert from the Regional Crime Lab in Kansas didn't have an opportunity to conduct any independent analysis, but he read at least one of the reports from Gilchrist, and he corrected the faulty use of population statistics. He explained what the right statistic was 100%. So the defense really did present something to rebut the analysis, which was invalid. But the jury didn't buy it, and he was convicted anyway. And so it's possible he would have been convicted. In fact, we know he would have been convicted if Gilchrist had testified appropriately, because he then, and that's why this isn't a project necessarily about wrongful convictions. He had his conviction reversed twice based on challenges to the forensic testimony. First, he had his conviction in death sentence reversed because of her statements that McCarty was physically present during the crime, and the court said, the court used the word improper to describe that and reversed his conviction because they said the science doesn't support that. And there was a second trial. At the second trial, Gilchrist obviously did not say he was in fact there. I can tell from the hair it was his. She didn't say that. She testified according to the criteria that I described. She said the hairs were similar. He could have been the origin of the hair found at the crime scene, and he was convicted based on that appropriate testimony the second time around. That testimony was challenged on appeal, and it wasn't reversed. He had a new sentencing hearing, and then later on during habeas filings they find out something very different, which is that there were these notes concealed where Gilchrist originally said no, the hairs excluded him. So a lot of different things happened in that case, but one lesson of that case is that just because the science is within appropriate parameters doesn't mean an innocent person can't be wrongfully convicted, and it doesn't mean a guilty person can't be convicted properly. The interest here in working on this project is to illuminate the types of errors that we want to prevent, just to ensure the integrity of science in the courtroom. Another Tulsa case that I mentioned was Timothy Durham's case, and I just wanted to touch on a few other cases and not just that one sort of behemoth of a case involving multiple kinds of errors. In the Timothy Durham case, the victim identified him as the attacker. He had 11 alibi witnesses who said he was at a skeet shooting competition at the time, but the jury didn't believe his alibi, and he was sentenced to 3,100 years in prison. So a long sentence, which he couldn't possibly serve, and he didn't. That was the case where the analyst, talking about the hair, talked about the hair could only come from 5% of the population because of this unusual reddish hue. She said these hairs were especially light. I've never found any pubic hairs as light as these before. Although inexplicably also mentioned that there were unaccountable differences between the hairs found at the crime scene and the defendant, and didn't explain what those accountable differences were. One wonders whether there should have been an exclusion there. You can't tell. Also talked about an unusual characteristic. And again, there's no empirical data to suggest that any particular kind of microscopic characteristic is shared by only a small part of the population or not. But she said she'd never seen a hair before like this. Never, she said, that was from a Caucasian person, and that would curl up and was hard to straighten under the slides, so sort of had a kinkiness to it. Now, actually, there are quite a few other exonerees who are Caucasian, and the analyst said, I've never seen a hair before that would be curly or kinky in this fashion. So there's yet another characteristic that was used to bolster the idea that these hairs were rare, only 5% or even less. I've never seen a hair like this. But maybe more interesting for those of us, because we now live in the DNA era, This case also involved early DNA analysis and not just hair analysis. Lots of these cases, again, had multiple forensic types of analysis involved. And this was early. It was DQ alpha DNA testing, which involved certain DQ alpha markers, some of which were shared by chunks of the population. Not big chunks like ABO testing, where it's 40% of the population is type O or whatnot. But here, the analyst initially said that Durham's DQ alpha type was shared by 5% of the population, but didn't explain, well, what markers were found in the crime scene evidence. What is the pool of people that could be included by the markers that were foreign to the victim? On cross-examination, when pushed by the defense lawyer, who actually did recognize the issue, he explains that actually, no, it's a larger group. It's 10% of the population that could have contributed to the sample. But so on cross, the problem was corrected. And the error had nothing to do with the testimony. But in the analysis, later on, when retesting was done, it was clear that there was a misinterpretation, that Durham was falsely included, and the difficulty arose from the difficulty of separating a mixed sample, sort of a related problem to the issue of interpreting mixed samples back in the conventional serology era. Here, the laboratory had failed to do the quantification or the separation of the male and female fractions during a differential extraction that they do to try to isolate the semen stain. And so with the victim's alleles, when combined with those of the true rapist, produced a false reading that looked like Durham's. And so it was an error in testing. Those kind of errors, we're reviewing trial transcripts. Those trial transcripts don't allow one to say typically whether what happened in the lab was mistaken or not. Typically in these cases, retesting is not done. If DNA testing exonerates, good. A mistake was corrected. We hopefully release the person from prison. We don't necessarily go back and see whether the hair analysis was done right or recheck the ABO blood typing. In a few cases that's come to light that there was an error. They said the person was type A and actually they were type B, something like that. But that typically isn't done in these cases, and so it's not something we can speak to. It's not something that comes up very often. But this is a case where apparently laboratory error did come up after the fact. But because his case was in the DNA era, he served only 3.5 years before being exonerated. And in 1996, DNA testing excludes him and points to another person, a convicted rapist who'd apparently committed suicide a month after Durham was charged. One final case I'll talk about before I stop and take questions. The case that you all may know from John Grisham's book, The Innocent Man, involving Dennis Fritz and Ron Williamson. That case was interesting because a lot of hairs were compared. And it's also interesting because it wasn't only the problem of a false positive. Innocent people were wrongly convicted, but there was also a false negative. And it may very well be, our study looks at exoneration cases. It may be that there are more false negatives out there, and that having better standards to ensure that scientifically valid interpretation of results occurs may end up being of far more importance to scientists working for the state and for the state. Here there was a false negative in that the real killer's hairs were examined, and he was an informant to the police in that case. The examiner looked at his hairs and testified equivocally that he compared those hairs to the crime scene hairs and had excluded that person. And now we know that person did it. And so it's one of these unusual cases where we know that there is this false negative. More troubling to the 10th Circuit, when they reversed Williamson's conviction, the analyst claimed to have done a direct comparison with this person's hair and the crime scene hair, and it turns out he never actually did that. So never compared this person's hair with the unidentified crime scene hairs. There was also, the case otherwise looked similar to other exonerees cases. There was analysis of serology. There was a similar kind of issue to the Curtis McCarty case, where they were assuming that the victim was a non-secretor that produces no antigens. Coincidentally, both Williamson and Fritz were non-secretors that produce no antigens. But then the analyst says, non-secretors, that's only 20% of the population that could have done this. Again, if the victim's fluids were masking everything, or if the reason for observing no antigens was that the material had degraded, because after all it was a murder. Any male could have been the donor, but that wasn't the testimony. Some cases, and a fair number, although less than half, had valid testimony where analysts clearly explained these principles. and provided certain models for how you would want testimony to conform to the available data. So, for example, in a Tulsa case, in Arvin McGee's case, the analyst was quite clear that because there was a type that was foreign to the victim, where the victim was a non-secretor and the defendant, Arvin McGee, was a B secretor, that was probative information, and that was talked about the group of B secretors that could be included. And so that testimony was appropriate and it clearly explained the relevant statistic. I'm just about out of time. I just want to say a couple other things. There's one other interesting case, which I won't have time to get into, where a person was clearly convicted not just because of forensic science, but because of the eyewitness testimony. And in lots of these cases, there's other evidence, as I mentioned. Here we know about a linkage, which is also interesting because although we don't know how the jury decided these cases or what they relied on, evidence in criminal cases is related. And there's a case, for example, where the person confessed, so they decided not to do DNA testing that could have exonerated him. One of these Oklahoma cases was the reverse. In Jeffrey Pierce's case, the victim apparently identified two people who were not Jeffrey Pierce and said, "Oh yeah, they look like my attacker." But the victim was told, Joyce Gilchrist compared the hairs and excluded both of them, so don't worry about that. And then later she picks Jeffrey Pierce, and they say, "Oh, those hairs, those could have come from him." And so, that was an example of suggestion to an eyewitness, which is a totally separate type of problem. But it tied the forensic science to another piece of evidence in the case. There are lots of types of forensic science that I haven't talked about that occur in other states. I just wanted to give you a few examples because really all this is a collection of interesting examples. There are some systemic issues that these examples point to, and basically it's just that, the defendants in these cases at least typically didn't have experts. They didn't recognize these problems when they came up, nor did judges usually. There were some cases like McCarty's where the appellate court actually reversed, saying that the forensic testimony was troubling, but not typically. Forensic science, as Dr. Eric Lander, one of the leading geneticists in our country, said in 1989, forensic science is virtually unregulated, with the paradoxical result that clinical laboratories must meet higher standards to be allowed to diagnose strep throat than forensic labs must meet to put a defendant on death row. Now, 2 decades later, there is not legislation or any source that one can go to find standards regulating the quality of non-DNA forensic disciplines, nor the content of reports and testimony. Now, we have the example of the hair testimony where the FBI came together with their symposium and provided sound standards that, look, there are limitations, there's not data on hair, so all you can say is that the hair looks similar, or could have come from the defendant, or you can exclude. Defense lawyers didn't know that. Judges apparently didn't know that either in these cases. And so, the incidence of invalid testimony in these cases, maybe not surprising that it wasn't cured in these particular cases. We don't know how many cases there are out there again. Not that many crime laboratories have conducted inquiries after these kinds of exonerations, although in Oklahoma, as you know, the governor ordered an audit. And in a few other cases that's happened. But Peter and I aren't so much interested in looking backwards. We have these backwards-looking, these old cases, much more interested in what could be done in the future. And really, we look to the scientists. Most of what forensic scientists do is not DNA testimony. By some accounts, it's less than 2% of requests to crime labs in the United States. There's still quite a bit of room for important work that does involve, this kind of subjective comparisons that we were talking about. And so what's important is for accurate presentation of those results. If the empirical data is limited, then you want those limitations to be explained. And this is an important time and an exciting time because there is this National Academy's report which may provide an occasion for scientists to join in efforts to improve forensic science and to dedicate additional resources to the study of unresolved questions in forensic science. So again, just as much needed federal legislation could fund research and improve the reliability of assays used where life and liberty are at stake, it could also delegate the task of coming up with standards for valid forensic science testimony and report writing. And again, the invalid testimony that we found in this collection of cases is troubling, and it happened some time ago. But again, this is an opportunity that scientists can use to restore our confidence in forensic science by establishing a new foundation for its presentation in the courtroom. Thank you all very much, and I hope we get some questions, because I'll be here for quite some time after the talk, and look forward to talking to you some more. Oh, yes, please. Yeah. Hi. Yeah, there's about a third of the cases the DNA testing resulted in either a cold hit or some kind of a non-cold hit, locating, and many of those people have been subsequently convicted. Some of them confessed. So it's about a third. And some of these cases are still open. They're still running those profiles through databases. And some of these cases certainly involve, serial rapists, serial murderers who committed additional crimes, and so these are unresolved cases, and there are consequences to the error that happened the first time around. And so that's something really significant about DNA testing, that post-conviction, that not only can it free someone who's innocent, but in a lot of these cases it tells us something about who really did the crime. Yeah.
What happens to the exonerated after they're exonerated? Are they able to live a semi-normal life?
Many of these exonerees never get any kind of compensation. I used to be a civil rights lawyer in my former life, and civil rights cases are hard. The standards are very difficult. Some of these exonerees try to proceed with civil rights cases, and some of them have evidence of the kind of fault that you have to show to win, and some don't. And so, there are a few exonerees who win multi-million-dollar verdicts, and there are many others who get nothing. More states have passed statutes basically saying, look, we shouldn't talk about fault. These are people who suffered something. Let's just give them some kind of automatic compensation, whatever it is, a few $1,000s a year, quickly, so they can get on with their lives, since litigation, as you all know by now, takes a long, long time. And so, I think those statutes make a lot of sense. They may be less expensive for the state, too, to avoid these multi-million-dollar verdicts for the people who sort of win the litigation lottery. But, there's a separate question of sort of how do you adjust to life after exoneration. We know something about how prison affects people, but obviously it affects people very differently if they're in prison and the whole time they know that they didn't do it. It's a different kind of prison experience, and one that therapists don't particularly have experience with. What is that kind of sort of PTSD that one might get like? There are some exonerees though who I've worked with, who adjusted remarkably well, and some who are ruined. Some of these people were sort of usual suspects types who weren't doing so well before and are doing worse afterwards. And there's some exonerees who've gone and committed crimes that we think they probably did commit after they were exonerated. So it's really a mixture. There's a wonderful Time series where they did interviews with more than 100 exonerees, and they have audio that you can click on, and they have a kind of interactive chart and talking about what happened after exoneration. And so that's a neat resource that you can look at to sort of hear some of the stories of these people after they got out. Yeah. Many years, usually, yeah. Oh yes, that was often the case. Yeah. I think that's the case with most of these. Most of these exonerees were convicted before DNA testing was widely available. Most of these convictions were in the 1980s. Well, and in some of these cases, right, the DNA testing that was done couldn't get a result because it wasn't, they couldn't amplify in the same way that we can now. There are some cases where the DNA technology had not changed, and there are a few cases where the DNA excluded the person at trial; they were convicted anyway. but then there was a cold hit with someone else in the DNA database, and that added a new layer of, a new type of evidence of innocence to the original DNA exclusion. So some cases like that. Yeah.
Did you review the testimony of
I just sort of this. It was very striking. Right? It was the final impression that the jury was left with at the end of the direct. We can't tell from the face of the trials transcripts typically what kind of discussions there were between the prosecutor. Sometimes if the prosecutor mentions the forensic testimony and describes it in some detail in the openings, then they've talked about it in advance with the forensic scientist. They presumably have seen some kind of a report, but they may not know what the scientist is going to say on the stand. Obviously, if there's a pattern like that in other cases, you might think that the prosecutor is collaborating in some way. But we typically don't know. These transcripts don't tell you that. I think that the scientist has an obligation to provide accurate testimony regardless of what the question is asked. Should say, we can't answer a question like that looking at hairs. We can't uniquely identify someone. There were some cases where forensic analysts, there were quite a few cases where forensic analysts testified clearly and appropriately and were quite clear about the limitations of what they were saying and the technology at the time. And then you have a prosecutor who during closing says, yeah, and remember what that analyst said? They said that this hair came from the defendant, something like that. And so maybe if the jury didn't remember the forensic testimony and didn't understand the subtleties of it, then maybe they would be left by the wrong impression. And that's a harder problem to cure because there's not a lot of regulation of the kinds of arguments that prosecutors can make during closing statements. There are very few cases in this set where prosecutors actually suffered a reversal based on closing arguments that misstated otherwise valid forensic testimony. There are amazing cases where the prosecutor even said, forensic analyst said it was this guy's hair, and the forensic analyst said the opposite, said, the evidence is inconclusive. The hair is too small to say anything about it. It's too shaving. You don't have whole hair. The defense lawyer would even point it out and said that's the opposite of what the forensic analyst said. And the court would say, I can't really remember that stuff. The jury's supposed to remember things. Let them sort it out. That was basically, and then they sort of gave a curative instruction to the effect of, jurors, you may remember what the forensic analyst said, so to the extent that what the prosecutor just said contradicts, sort it out. And that's a separate kind of problem. Again, it's very rare, even where it's clear that the prosecutor said something that the forensic analyst didn't, that a court did any kind of a reversal, because they give prosecutors leeway to do arguments. And so there's sort of a separate problem, assuming that forensic scientists provide sound scientific testimony, as presumably they typically do. What happens when the lawyers mess it up and exaggerate it and misunderstand it? It may help to some extent for there to be some source where a lawyer can go see, the standard is you can only say that hairs could have come from someone, because at least maybe they could counter it better in their closings. But that still might not prevent the testimony from misleading the jury. We can hope for some improvement if there are clearer standards out there, but what can you do? Yeah, Lynn. One thing I can say is that it's often clear that the defense lawyers didn't understand the forensic science. They very rarely had experts. I already mentioned that. But in addition, it's very rare that in a case where there's some glaring problem with the scientific testimony, the analyst says, 5% of people have this reddish yellow hue. It's very rare to see the defense lawyer on cross ask any questions about that. Now maybe they don't really understand it and they don't want to draw attention to this damaging statistic, right? So if you're a sensible but poorly informed defense attorney, maybe that's the best thing to do. You don't want them to explain why that 5% statistic is so powerful, right? You don't want to get into it. but for whatever reason, very, very rare to see defense lawyers do any kind of cross, even on the sort of subject matter of the error, in the cases that had these kind of errors. And it may be also that they didn't have experts, they weren't educated on issues, they didn't understand the standards. So that was something that we did see. Yeah.
So our question, this is a problem. Suicide, fraud, Albert, they don't address the problem.
No.
The National Academy report can't address it either. So
may not.
If your safety proposal would be, if more dire, bring the next extra witness in, and that extra witness. What's your utopian model that allows regulation of the witness and regulation of the jury and regulation of the jury?
I suppose the utopian model would be some sort of entity, group of forensic scientists and other scientists maybe, that would at least make public standards that everyone could look at, just to be educated on what the boundaries are, the scientific boundaries are of particular disciplines. That would be a start. That's only one part. Hopefully, whatever entity the National Academy created would create some kind of entity, and hopefully there would even be in the future a regular review of testimony, even by the forensic laboratories themselves or by this body, to see whether the standards are actually being comported with. There's a problem with some standards that have been published with some disciplines. For example, in the area of bite mark examination, there are standards, on a working group website, but they say that bite mark examiners can find anything from just bite mark came from this person to reasonable dental certainty that the bite came from someone, and then no guidance on what satisfies any of those possible conclusions. So there are guidelines, but they're guidelines that don't provide guidance, and they cover a gamut of statements that aren't supported by any data. So those are problematic guidelines, and that's why you'd want a scientific body that's also doing research, hopefully, to look at these standards.
One last question.
Oh yeah, no, please.
In terms of the validated things, what you're getting referencing is always peer-reviewed literature. And you have peer-reviewed literature, you have personal communication with someone, and you have the personal experience of the examiner or the scientist. You said behavior.
Oh yeah.
How do you?
But
it sounds like you're saying peer-reviewed public literature is.
Oh, not necessarily. So, if there's a forensic discipline where there is no research like that's been conducted yet, then the testimony should reflect that. So, if there hasn't been any peer-reviewed or any other kind of databases or anything on the frequency of hair statistics, then the examiner should just say, these hairs look similar, but we don't have data. I can't tell you that the population shares this hair. All I can say is that they're similar. Now, whether there are separate Daubert issues, I'm not going there. The idea is just that the testimony should reflect whatever the state of the empirical research is.
One more question before we go.
I'm wondering if you have a sense of how many states work. Earmarking knowledge.
Well, there's federal funding that's available now. Hopefully, will become more available, but it can be expensive. In Virginia, the Department of Forensic Science is really doing a landmark and kind of incredible project, looking at a couple thousand old cases, quite time-consuming, and crime laboratories are strapped, and it certainly takes resources to do this still additional work. Many of these particular cases, innocence projects were happy to foot the bill and pay for some other lab to do the testing. But you'd hope that you wouldn't have to wait for some post-conviction lawyers and an innocence project to get involved. You'd hope that the state would do it itself if it thought that there was a good reason to do post-conviction testing. It's sort of doesn't make sense for the process to work that someone has to write letters to some innocence project and these outsiders sort of sort through the letters and pick some cases, however many they have time to work on, and then they make a request, and then maybe they get testing. And so, it's really noteworthy that we're first starting to see some cases where crime laboratories themselves are getting retesting or getting funding to do retesting efforts on their own. It's something really exciting. Yes, last question. Well, there was a proposal here, right, to create an innocence commission in Oklahoma, and I take it that it stalled or didn't get passed. But there are not very many innocence commissions in the U.S. It's sort of a unique idea to create a kind of a innocence-focused alternative to the regular post-conviction system. There's a commission in Virginia, but it's not clear. It's sort of a volunteer ad hoc group that doesn't really have any connection with the court system or any authority. There's a different model in North Carolina where there's an innocence commission that was convened by the Chief Justice there to actually look at old cases and refer them to the courts if they think that cases are problematic, and they have an interdisciplinary body with law enforcement and prosecutors and defense lawyers and legislators all as a committee looking at cases, and they can recommend a vacatur of a conviction. So that's one model. The UK has something like that. Canada has this way of doing these special inquiries. And so there's some who say our post-conviction system isn't good at judging innocence. We need alternatives to focus on these unusual cases. And hard to say whether these experiments are going to work. They haven't been tried in too many places in the U.S., but maybe there'll be more experimentation with it. Thank you.
Well, Professor Garrett, thank you so much. This was truly consistent with the tradition and the history and the legacy of this lecture. As just a small token of our appreciation, we want to present you with a book by the president of the university, Stedman Upham, and it is of the Native American portraiture of Edward Sheriff Curtis.
Oh, wow.
Also, we'd like to invite everyone to hang out, chat, schmooze for a bit. We have a bit of a reception outside, and we really appreciate your coming here tonight and hope to see you at future events here at the law school. Thank you.
Thank you.